Hello, welcome to our Legacy Wealth Planning webinar. My name is Cheryl David, and I'm the founder of the law offices of Cheryl David, an elder law and estate planning law firm serving Greensboro and Guilford County in North Carolina. We're going to cover some important information today, so before we begin, let's go over a few housekeeping items. First and foremost, please turn off your cell phones and remove any potential distractions. I'm going to show you how to protect your family's future, and I don't want you to miss a thing. I also want to point out the question and answer box below this video window. We won't have time to get to all of your questions today, but if you do have a question, please feel free to type that in here and I will respond via email as quickly as I can. And finally, we love hearing your feedback, so if you're talking about this webinar on social media, please include the hashtag #LegacyWealthPlan so we will be able to see it. It's also a great way to share this information with other families you know. So with that out of the way, let's talk about why you're here. Put simply, these are perilous times in America, and no group is impacted more than seniors and retirees. After you're gone, it's your children, grandchildren, and beneficiaries who will face the dangers. For example, research shows more than 15 million lawsuits are filed in state courts each year alone, and almost 1 million people petition for bankruptcy. Divorce is also on the rise. In fact, it's no secret that our divorce rate is the highest in the world, and a huge percentage of Americans have been divorced and remarried several times. And then there's the debilitating expense of nursing homes and long-term care, something many of us will need down the road. The cost of nursing home care increases every year, and here in North Carolina, the average annual cost for a nursing home room is just under $79,000, and that's just for a semi-private room. Costs for medical care are also out of control. In 2013, over 20% of American adults were struggling to pay their medical bills, and 3 out of 5 bankruptcies in 2014 and 2015 and even in 2016 were due to medical bills. So again, it's no surprise that so many Americans are concerned about their family's future. Now, in the past, most people used estate planning attorneys to address these issues, but the surge of free online documents and do-it-yourself sites like LegalZoom have produced some very poorly drafted documents that left clients' estates and their families completely exposed. Of course, these vulnerabilities weren't discovered until it was too late, and as a result, entire legacies have been lost and families devastated. The really sad fact is that most of these tragedies, with a little planning, are completely avoidable. This reality has created 6 major concerns for my clients. First and foremost, they want to make sure that they get to pass on their hard-earned wealth without the government or courts being involved. Next, they want to avoid any unnecessary taxes and fees. They want dignity in their final years and to avoid going broke paying for nursing home costs or other crushing medical expenses. Once they've passed on, they want to make sure their family is protected from predators and creditors. And perhaps most important of all, they want to make sure the family is not torn apart with fights over money or possessions. Finally, they also want to find a way to capture and pass on their family's story, life experiences, wisdom, and values to the generations that follow. So there you have it, 6 major concerns. 1, no government. 2, no taxes or fees. 3, avoid nursing home costs. 4, protect the family from creditors and predators. 5, no family fighting after they're gone. And finally, a way to pass on their wisdom, values, and life lessons. And that's what we're going to talk about today. In fact, I'm going to give you the information you need to make sure none of these life-wrenching events happen to you or your family. And if you'll hang around until the end of the webinar, I've got a special bonus for you that will make the process even easier. Now, in case you're wondering why you should listen to me talk about these things, let me tell you a little bit about who I am and what brought me here. First and perhaps most importantly, I'm a wife, a mother, and a daughter, so I know what it means to protect your family's future. I'm also a board-certified estate planning attorney with the National Association of Estate Planners and Counsels, and I've devoted the last 29 years of my life and career to educating and protecting families just like yours. Now, I didn't start out my career as an estate planner. It was only after the tragic death of my sister to meningitis that I woke up and found my calling. I remember that dreaded phone call. I'd just put my daughter down in her crib. I remember what we had for dinner. I remember the drive to the hospital and trying to comfort my parents and brothers. And I remember the loss and shock we all felt at her funeral. It was then and there that I left litigation and decided to devote my life to making sure that families are prepared for the unthinkable. So I'm glad you could join us for this important webinar. Everything we share with you today is based on research, studies, and real-world experiences working with families just like yours. And by the time we're done, I promise you'll have a much clearer understanding of how to protect both your assets and your loved ones from the dangers we all face today. So given everything we've mentioned so far, let's address the obvious question. Why don't people plan? Over the years, we found there are two main reasons people don't plan for catastrophic events. The first is procrastination, and we've all done it. We have a tendency to put things off, especially when it's something we don't want to face. The problem with that approach is that the infamous tomorrow never comes. It's always in the future, and those important tasks never get done. The second reason is simply a lack of knowledge and learning. And just so you know, this one isn't really your fault. Estate planning isn't exactly the easiest topic to master, and unless you're an experienced estate planning attorney, there's just no way you could keep up with all of the changes in laws and regulations. So my job today is to clearly explain those laws and let you know all the benefits available to you and your family with proper planning. During our time together, I'm also going to talk about what traditional estate planning is and why it has failed most Americans. In fact, one commentator said that traditional estate planning has done more harm to America than the estate tax and probate ever could. We'll discuss why most of you who have an estate plan are sitting with documents that may not address your needs, and in many cases won't work at all. The sad part is that you're not even aware of it. And finally, I'll show you what estate planning can look like from an entirely new perspective, one that addresses what really matters most by starting with your core values. And don't forget, I've got a special bonus for you at the end of this webinar that's going to help you put everything you've learned here today into action. Now, one final thing before we get started, the end result we're talking about here is inevitable. Everyone here, without exception, is going to die, and some sooner than others. In addition, many of you will suffer an illness before death that renders you powerless to handle any of the functions of daily living. I know that's a depressing picture, but it's our reality, and it's why this information is so important. See, this is one of those topics that we don't really want to think about, which means we also don't want to think about how our death or disability would affect those we love. So rather than throw a bunch of facts and statistics at you, let me just show you what it looks like when you don't have proper planning in a real-life situation. And to do that, I want to introduce you to Bill and Mary Jones. They live right here in North Carolina and have been married a long time. Over the years, they've built what they considered to be a modest estate, but when you add in things like their retirement accounts, the real estate they own, their investments, life insurance, and personal property, their estate is actually worth around $700,000. Not so modest anymore, is it? Bill and Mary also have 2 children, John and Susan, and it's a concern over their future that inspired Bill and Mary to create a solid estate plan. Now, as is the case with many families, John and Susan are like night and day. Susan was the golden girl who always excelled at school, was responsible, and wisely looked after her finances. She is a practicing CPA with 2 wonderful children. John, on the other hand, never quite conformed. He was a rebel as a child and continued that behavior into his adult years. He's never really held a steady job for very long and has been in and out of relationships, including 2 marriages. His biggest problem, though, is his addiction to drugs and alcohol, and despite a prolonged stay at a rehab center, John has never really been clean and sober very long. Bill and Mary have been bailing him out of trouble all of his life and are really worried about what he'll do with his inheritance. So let's look at Bill and Mary's estate planning options. One of the options I hear usually as a joke is to spend it all. Of course, that's not realistic and certainly not good planning. After all, none of us know how long we'll live, and we don't know what kind of medical emergencies we may encounter, how well our investments will perform, or how much the cost of living will rise. And if you're like most people, you understand the fear of outliving your money. Well, that's the fate you risk if you adopt the spend-it-all tactic. Another option is to die intestate. This simply means you left this world without making any written estate planning provisions at all. No will, nothing, nada. The problem with this strategy is that it's not really a strategy at all. If you die intestate, you give up the right to decide for yourself who will get your estate, when and how they will get it, and under what conditions. The courts will decide that for you after a potentially lengthy and expensive probate process. This option also ensures that your estate, and thus your family, isn't protected from creditors, lawsuits, con artists, and taxes. A third option is joint tenancy. This basically means that you hold title to your assets jointly with your spouse or another family member or friend. Joint tenancy passes everything to the surviving title holder when the other dies, making this seem like an easy and inexpensive way to avoid probate. But that's not actually the case. Joint tenancy actually just delays probate, and when the surviving spouse dies, the asset will absolutely be probated if there's no proper estate planning in place. And one last concern before we move on. If a party becomes incapacitated, that is, unable to manage their own affairs, the right to manage the property does not automatically pass to the other owner. That means you could potentially have a property that cannot be sold or even refinanced without court approval. Okay, so let's look at your next option, a basic will. This option is a legal document that names who will handle your estate, called your executor, and it lays out how your estate will be distributed. Basically, it allows you to say who gets what. This is definitely a better option than the options we've discussed so far, but again, a simple will is very limited in what it can do. You can't add any contingencies for an inheritance. For example, whatever assets you bequeath are given to your heirs in a lump sum. There's no condition or milestone that must be met before the property is distributed. Also remember that a will must be probated. So if one of your goals is to avoid probate, a will is definitely not your solution. All wills go through court. So what's the big deal about probate? Probate is basically the state's way of distributing your estate after you're gone. Its primary purpose is to change the title on the property you own so that your family can manage the asset, sell it, refinance it, lease it without your approval. It also settles any family disputes, pays your creditors, and ensures that all assets are distributed in accordance with the law. So, in the absence of something better, such as a solid trust estate plan, probate is absolutely necessary, but it can also be extremely expensive and time-consuming. We're talking about court filing fees, publication and bond fees, executor fees, and attorney's fees. And yes, these fees can add up very quickly. It can also take months, even years, to complete. The next option we're going to discuss today is the bare bones living trust. This document is designed to avoid probate, but unfortunately, most of these documents are so poorly created, they just don't work. Do you want to know why? Besides the fact that they almost never have any provisions which provide the protections we're going to talk about, most of them are never funded. Funding means that you've transferred assets into the trust. That is, actually changed the title of the assets so that they're officially owned by the trust. Without funding, you've basically got a document that has power over nothing. It's an empty box. And when you buy a bare bones living trust, like the bargain documents you get off the internet or television, there's no provision or procedure to make sure that funding ever happens. We see it every day. Clients bring these documents after their parents have died, and then sadly, we have to tell them to get ready for a long, drawn-out, expensive probate. They can't believe it because mom and dad were telling them all along that they had looked after everything. They had signed their living trust, so they thought everything was okay. We have to explain that a trust without assets is like a beautiful pen with no ink. Pretty, but worthless. Now, at this point, Bill and Mary don't have any kind of estate plan in place. Like most people, they have busy lives with hectic schedules, and despite their good intentions, they just haven't gotten around to taking care of this very important task. Put simply, they thought estate planning could wait. But then Bill has a stroke. It's a mild one, and after a 3-day stay in the hospital, he got the okay to go home. His wife, Mary, however, is quite alarmed by the whole experience, and she decides estate planning is their next priority. They contacted an attorney they had worked with in the past, and after explaining this wasn't his specialty, he prepared a will for each of them. Both named the other as their primary beneficiary, and they agreed that their children should receive everything in equal shares after Bill and Mary had both died. They also went to their local funeral home and prepaid for their burial plot and other funeral arrangements. Afterwards, they congratulated themselves for finally taking care of these important details, and they felt confident in the plan they had created. But if you want the truth, they had barely begun to address their estate planning issues, and unfortunately, they would soon find that out for themselves. Just 6 months after leaving the attorney's office, something terrible happened to Bill. Now, when I ask this question at a live seminar, most of the audience will give the same answer. They think Bill dies. But the biggest risk for most people is not death. It's becoming disabled, and that's what happened to Bill. After his minor stroke several months before, he had a massive episode that left him permanently disabled. And suddenly, Bill and Mary were looking at long-term care expenses. When you're disabled and unable to handle many of the tasks of daily living, you're categorized as someone who needs long-term care. This includes medical and non-medical care for people who have chronic illness or disability, not short-term problems like an accident or illness that will be solved soon with medical care. Most long-term care is to help people with the regular activities of daily living, such as dressing, bathing, and using a bathroom. It can be provided at many different locations: in the home, in the community, with adult daycare, in assisted living facilities, or finally in nursing homes. And it's important to remember that you may need long-term care at any age, or you may never need it at all. However, this year alone, about 9 million Americans over the age of 65 will need some type of long-term care. By 2020, 12 million older Americans will need long-term care. Most will be cared for at home by family and friends, because these are the sole caregivers for 78% of the elderly. And a startling government study found that 40% of those who reach age 65 will need to go into a nursing home at some point before they die. Now, there are only 5 ways to pay for these huge long-term care expenses. You can dip into your savings and pay it all yourself, but as you can imagine, at $79,000 per year, paying for nursing home can quickly bankrupt you. The second option is long-term care insurance, but this is something you need to plan for and purchase ahead of time. It can be very expensive, and if you don't end up needing it, that's a lot of money to just throw away. Remember, regular health insurance won't pay for these long-term custodial care bills, and Medicare only offers limited benefits. It also won't pay for chronic illnesses that impact the activities of daily living. So what's left? Medicaid, the government medical welfare program, pays for about 50% of the nursing home cost of Americans. This is a federal and state partnership that steps in to pay for medical and long-term health care expenses when most of a person's wealth has been depleted. In other words, Medicaid will kick in only when no assets are available from any other source. And finally, special VA benefits are available to veterans who apply and are approved. This is something we always check on for our clients when preparing an estate plan. So there you have it, 5 ways to pay. Use your own money, buy long-term care insurance and hope you get enough coverage, see if Medicare will cover some part of the expenses. If you're nearly broke, you may qualify for government welfare through the Medicaid program, and finally, the Veterans Aid and Attendance Program for qualified veterans. In this instance, Bill and Mary were lucky. Rather than face the extraordinary expense of nursing home care, Mary was able to provide most of the ongoing care that Bill needed. But they were still facing a tough question: who will handle his affairs? See, if you become disabled or incapacitated, someone must get permission from the court to act on your behalf, even if that someone is your spouse. So Mary must go to court and initiate a process called guardianship. We also refer to it as a living probate. Living probate is the court proceeding to name your conservator or guardian to look after things. Now, normally, we think of probate as something that occurs after people die, but living probate works a little differently. It happens when you're alive but no longer able to handle your affairs, and can be as bad or even worse than a death probate. In a living probate procedure, the court chooses someone, and not necessarily a person of your choosing, to use and manage your assets on your behalf. It's the only way to ensure that no one takes advantage of your situation. But obviously, this process can easily become a nightmare. For starters, you'll be brought into court and pronounced incompetent to handle your affairs. So there's definitely some public humiliation to contend with. Secondly, the court is now in control. You don't get to name who your conservator or guardian will be. The court does that for you, meaning you have little say in your own affairs. It's also very time-consuming, as I'm sure you can imagine, and because your family now has to disclose all your personal family information, there's the risk of other not-so-scrupulous parties getting their hands on this sensitive data. And yes, it can be expensive. There are court fees, attorney's fees, accounting fees, guardian ad litem fees, and because the court must be updated on a regular basis, these fees will continue to grow. So Bill and Mary go through a living probate process, but unfortunately, a few years later, Bill passes away. They had the prepaid funeral arrangements with the local funeral home, so Bill was laid to rest, but Mary must now go back to court and deal with the death probate process. Now remember, probate allows the court to step in and ensure that property and assets within the estate are distributed to the rightful heirs. It pays the creditors, it takes care of any taxes that are due, and it legally transfers the title to any assets that will remain in the family. But it can also be lengthy and expensive, and the entire process is public, so anyone can get access to your private information, all of the details in your estate. But let's not just focus on probate, taxes, nursing home costs, and vulnerable children. Something far more valuable has been lost to the family. Most of this discussion is about money and financial assets, but what about the wisdom and life stories Bill had to offer his family? Where are these preserved? The truth is, when Bill died, his life story died with him. Yes, Mary and his kids might remember milestones in his legacy, but what about the grandkids and the great-grandkids? At some point, Bill will just be another name on the family tree, and his descendants will have no knowledge of the passion, love, and contribution his life represented. Bill and Mary's little estate plan didn't address these issues at all. It's so crucial that the family have a way to capture Bill's biography before he dies so his memory and life will not be lost to future generations. And we're not done with this story yet. After Bill passed away, their neighbor Ralph came over to offer his condolences and help comfort Mary. Over time, Ralph visited more often, for a coffee in the morning, sometimes coming over for tea in the afternoon, or a night out at the movies. Ralph had lost his financial reserve when his first wife went into a nursing home, so Mary, in addition to being attractive, also has an appealing nest egg. So after a short courtship, he proposes to Mary. Now, remarriage is quite common and certainly not a bad thing. After all, we all want companionship. But Ralph has a couple of grown children, Ryan and Rachel, and from an estate planning perspective, the big fear is that the new spouse and his or her children are going to find a way to get their hands on the estate. And yes, this is also a common occurrence. There's no limit to the greed that pops up when money is involved. We've even seen cases where the children of one spouse got nothing from their parents' estate, and it all ended up in the hands of the new spouse's kids. And of course, Bill and Mary's simple will had no protection for something like this. But we have other concerns too. Mary lives another 10 years after Bill dies, and thanks to her wise investing and inflation, Mary's estate of $700,000 has now grown to a value of $1,400,000. But after about 8 of those years, Mary develops Alzheimer's disease and is no longer able to handle her affairs or properly look after herself. She has to be placed in a nursing home. And again, statistically, close to half of us will wind up in a nursing home or some long-term care facility sometime before we die. To show how the problem is growing, a recent study by the Alzheimer's Association declared that dementia is the biggest health crisis facing the world today. In fact, by 2050, many believe that 3 times the number of elderly will need care than the number we see today. Now, as we've already seen, those nursing home costs can quickly start to accumulate, and even though Mary only lives for an additional year and a half, at $6,600 per month, the family is faced with expenses of $118,500. These costs have to be paid directly out of her funds, and once again, Mary's family must go back to court to appoint someone to handle Mary's affairs. When Mary finally does pass away, the estate begins its final probate process. During this time, Mary's daughter Susan discovers that the funeral home where Bill and Mary purchased their prepaid plans has been sold. The new company won't honor the original contract for her mother's arrangements, and because Mary's assets are tied up in probate, Susan and John have to struggle to pull the money together to pay for Mary's final arrangements so their parents can be buried together. Now, because Bill and Mary's estate is well below the current estate tax exemption, there will be no federal estate taxes due. But once again, all the history and experience that have been accumulated are now lost, as no one took the time to preserve them while Mary was still alive. I think we can all agree that this has turned out to be an expensive estate plan so far, not to mention the time and emotional distress that the family has had to endure. But we're still not done with the story. After all the bills and taxes have been paid, John and Susan will still receive several $100,000 each from the estate, the remains of Bill and Mary's hard-earned wealth. And again, Bill and Mary's estate plan proves to be ineffective, offering no way to ensure that the wealth is not wasted once they're gone. Their simple wills dump a huge windfall on both John and Susan, and that brings us to a new set of concerns. The top 3 risks that parents worry about are divorce, opportunists, and lawsuits. Every client is worried about the son-in-law or daughter-in-law divorcing their child and walking away with a big chunk of the parent's estate. And why shouldn't they worry? With a divorce rate in America topping every other country, the chances of your kids having a long and happy marriage are not good. Parents also worry that someone will target their kids for get-rich-quick schemes, foolish financial investments, or even some well-planned scam. And finally, there's a real prospect that your kids could get sued with some judgment creditor walking off with your estate. Yet almost every estate plan drafted the traditional way delivers the asset straight into the hands of the children, regardless of whether the child is ready for that wealth or not. And this is what is commonly referred to as the divide, dump, and dissipate. So let's start with divorce protection. Bill and Mary never liked Susan's husband, Jason. They felt he was lazy and just plain bad news. But because Bill and Mary's estate plan called for an equal division of the assets, Susan and John received their inheritance in one lump sum with no safeguards or restrictions in place. Once Susan had received the money, she deposited her $700,000 in a joint account with her husband, Jason. And about a year later, Susan finally has enough of Jason's behavior and files for a divorce. But because she deposited her inheritance into a joint account, it becomes part of the marital estate, and Jason, the guy Bill and Mary never liked, walks away with about half of the money they left their daughter. Now let's move on to John. He never had money before, and suddenly he has access to a large chunk of cash. The first thing he does is buy a new car, but not just any car. No, he buys the ultimate American muscle car, a Corvette with all the bells and whistles. Obviously, he's going to blow through his inheritance if left to his own devices. But John's spending habits aren't his biggest problem right now. It's the IRS. Apparently, John has not been filing income tax returns for several years and owed more than $80,000 in taxes, interest, and penalties. As you might expect, the IRS walks in and scoops up the money right out of John's bank account. Obviously, Bill and Mary needed a better solution, and that's what we want to show you today. We've talked about what doesn't work. Now let's talk about the solution that does. I want to introduce you to something we call legacy wealth planning. This is a planning process used by a small number of highly trained law firms in the country and endorsed by the American Academy of Estate Planning Attorneys, of which our firm is a member. Legacy wealth planning is designed to protect the whole family, including your family values and history, not only while you're alive, but for generations after your death. And here's how it works. First, it addresses all the financial assets you've accumulated and shields them from conservatorship, remarriage, probate, divorce, lawsuits, creditors, and unnecessary taxes while allowing your heirs to access their funds. It also provides a way to shield the estate from nursing home or other long-term care expenses. And to avoid family feuds, all those special non-titled personal assets like family photos, memorabilia, and miscellaneous family treasures can be distributed to the heirs you designate. Second, and perhaps most importantly, legacy wealth planning gives your family the means to capture your biographies, life stories, wisdom, and the values for future generations. This entire process creates a responsible protection of wealth while you're alive and an orderly transfer after your death. With this planning, you can prepare, educate, and even provide incentives for your heirs to improve themselves before family funds are available to them. And the real beauty of this plan is that it works regardless of the size of your estate. Now, the main instrument that makes all this happen is a document called the Family Wealth Trust. And I'll show you how it works. You can think of your family wealth trust like a big box, say a treasure chest. When we create the trust documents, it has nothing in it. Remember we talked about funding earlier? Until that happens, the trust has control of nothing. So what we do is make sure that we move your assets into the trust as quickly as possible by changing the title from your name to the name of the family wealth trust. We'll transfer all of your joint property as well as any separate property you and your spouse may own if you're married, or just your property alone if you're single. In fact, just about everything you own should be in the name of the trust to give you complete protection, and here's why. If you don't personally hold title to your assets, they are not impacted by your death or disability. The Family Wealth Trust owns the assets, and that's what makes this plan so effective. Now, if you're wondering how you'll manage your assets if your trust holds title, not to worry. You'll still have complete access to your property, and you'll have authority to take care of all different tasks that go along with owning assets, such as paying bills, buying insurance, buying new assets, and yes, selling assets within the trust. In fact, to illustrate just how effective this solution truly is, let's give Bill and Mary a do-over, but this time we replace their wills with our legacy wealth planning solution. So let's start by looking at their family wealth trust. See, there are 3 distinct positions in every trust. The first is that of trustors. These are the people who own the assets that were transferred into the family wealth trust. Next, we have the trustees. These are the people who manage things, buying, selling, trading, and exchanging the assets in the family wealth trust, all the things you would normally do with your property. And finally, we have the beneficiaries. These are the people who have the right to spend the money and use the assets in the trust. And yes, Bill and Mary occupy all 3 positions. That means they can make any decision regarding the trust assets, including spending and using the assets in any way they wanted. Basically, Bill and Mary are in total control. It also means that Bill and Mary can amend their trust or even revoke it. They can manage the property, file their taxes just like they always have, and keep living and working and enjoying life. The trust has them and their assets covered. In fact, the only real change is that the trust now holds the title to their assets and sits silently, invisibly, ready to act if something happens to them. It's essentially their standby device. See, with a family wealth trust, someone of your choosing, a designated trustee, will be able to step in immediately and act if you become ill, disabled, or die without having to go through the court first. That's because a trustee looks to the instructions you put in your trust document for guidance, not the courts. In fact, there doesn't have to be any court involvement at all. With your family wealth trust, there's no living probate or guardianship, so if your spouse or you become incapacitated, there's no need to go to court. As the named trustee, the other spouse can continue to manage all affairs without any court intervention. And should both spouses become incapacitated, your designated successor trustee can step in and manage the trust and its assets on your behalf. So when Bill has his first stroke, Mary can continue to handle their affairs without interruption, no court order necessary, no legal fees. Mary will also go through death probate when Bill passes away, meaning she doesn't have to wait for the state to disperse the assets in the estate because they're owned by the trust. They also decided to add a funeral trust to their estate planning portfolio instead of prepaying for a funeral arrangement with a specific funeral home. A funeral trust is an insurance policy where the benefit pays out the next business day to the funeral home that the family chooses. It is also completely protected from probate and can be a very useful tool in Medicaid planning. That means that Susan and John won't have to worry about coming up with the cash to pay for Bill and Mary's funeral. Instead, they'll have immediate funds to handle the final arrangements in whatever way Bill and Mary expressed ahead of time, even supplying plane tickets to relatives that live out of town. A family wealth trust also includes the tools you need to capture your legacy, so all the wisdom, stories, and life lessons you've accumulated can be documented and saved for future generations. That means that Bill's life stories won't be lost. Instead, they'll be remembered by generations to come. And what about long-term care expenses? Well, in the event that you or your spouse needs some sort of long-term care, such as a stay in a nursing home, we can include what's known as a wealth preservation trust which will protect your assets and your home from long-term care expenses. When Mary got Alzheimer's disease after Bill died, she had to go into a nursing home. It was clear that her dementia prevented her from managing her own affairs any longer. And with their old estate plan, Mary's family was forced to go back to probate court and ask the judge for permission to manage Mary's finances. But now that they have a family wealth trust in place, there's no need for the court to be involved. Bill and Mary already designated their daughter Susan to take over if the surviving spouse became disabled. All the instructions Susan needs to carry out her duties are already set forth in the trust document. The legal costs to Mary's family to handle her affairs while she's disabled are essentially zero. And because they created the plan well before Mary needed to go into the nursing home, Medicaid paid all of her nursing home cost. This special planning just saved the family the $118,500, and they didn't have to go broke to be eligible for Medicaid benefits. Now, most people with an estate the size of Mary's won't have Medicaid pay the nursing home bills, but they could if they did proper planning. This is a situation where we, as your attorneys, let you know what rights you have to collect government benefits and what you need to do to make it happen. Once you understand the process, you alone can make the decision on whether we should proceed and create this additional level of protection. When Mary does finally pass 18 months later, the funeral trust activates again, allowing Susan and John to grieve for their loss without worrying about writing a check for the expenses. And once again, there's no death probate needed and no lengthy wait for assets to be distributed. The trust remains active after Bill and Mary are gone, with Susan acting as the trustee. And just as we did with Bill, the family will have the tools to capture Mary's wisdom, stories, and life lessons. We can also design the family wealth trust to block any estate transfers outside of the family. So when Susan decided to divorce Jason, she didn't risk losing half of her inheritance. The family's wealth will stay with the family regardless of how ugly the breakup might get. Worried about lawsuits and creditor claims? There is a way to draft your trust to exclude a portion of the estate from this kind of liability. This ensures that the wealth you worked so hard to accumulate isn't suddenly lost to a third party. So let's recap what we've accomplished so far. We've managed to protect the family from a living probate guardianship and death probate for Bill. We've protected the estate from remarriage disaster with Mary, and at the same time we've shielded much of the estate from lawsuits and creditors. On top of that, we avoided the living probate and death probate for Mary. With some additional planning with a special wealth preservation trust, we were able to save the family $118,500 in nursing home expenses. But best of all, we were able to create an action plan to capture both Bill and Mary's memories, life stories, and values for future generations before they died. Pretty impressive so far, right? So let's take a look at what happens now that Bill and Mary are both gone. Under their simple will plan, both Susan and John received lump sum payments after the estate had gone through probate. But as we saw, there are all kinds of problems with that scenario. John had drug and alcohol problems and wasn't responsible with money. And although Susan is responsible, she married a loser who's always looking for a get-rich-quick scheme. It's no wonder so many parents worry about leaving such large sums to their children. It's essentially setting your kids up for failure, and there won't be anything you can do when it all comes crashing down. But with the Family Wealth Trust, Bill and Mary had a new set of options to work with. Rather than giving their kids their inheritance outright, we're going to help Bill and Mary protect that inheritance and ensure the family's wealth actually benefits their children. In Bill and Mary's case, the Family Wealth Trust would hold on to the $1.4 million that has accumulated and designate $700,000 to a special subtrust for Susan. We call this a Family Access Trust. It will provide divorce protection for Susan in case she gets a divorce from her husband, Jason. We'll assign the other $700,000 to another type of subtrust called the Family Century Trust. This more restrictive trust will continue to hold John's share, and it will remain outside the grasp of John's creditors. Now, in the Family Access Trust, Susan is named as the trustee. That means she has the power to manage all of her assets. Of course, she also is the sole beneficiary, which gives her the right to spend the money or use the assets any time she wants. And because all the assets in the Family Access Trust are clearly defined as Susan's inheritance, meaning they're not commingled with any jointly owned marital assets, Susan's inheritance is not part of the marital estate that the divorce court gets to divide. It stays separate, and Jason will never touch Susan's gifts from her parents. That certainly must have made Bill and Mary happy before they died, knowing everything was safe. John's inheritance will work a little different. With the Family Century Trust, Bill and Mary named an independent trustee to manage John's share. The trust has specific instructions about how much access John has to his share, and if he continues to be irresponsible, the trustee will restrict his distributions. This also means that if John gets sued or has a serious accident, the trust assets will be protected. It acts like a sentry over John's share. So what if John matures and cleans up his act? Will there always be restrictions? In this case, Bill and Mary could include some incentive provision that motivate John to move forward responsibly with his life. They could require he be clean and sober, with periodic drug tests, for example. They could also require that he attend college with a certain number of credits each semester and have at least a B average. And they could insist that he maintain regular counseling sessions to deal with any problems he has. The truth is that list is endless, and the well-written trust provides guidance and motivation for John well after Mom and Dad are gone. Now, just looking at what we've accomplished so far, it's a no-brainer when choosing the kind of estate plan you'd prefer to create. But with the Family Wealth Trust, there's still more you can do. Many clients, for example, have children and grandchildren with special needs, and they don't want to leave a large inheritance that could cut off any government benefits. So in these instances, we add an optional special needs trust to hold the child's share and distribute smaller amounts that will not disqualify the child for benefits. It also helps to ensure that children who are least able to look after themselves have a secure financial base to get them through life. Now, I know we've covered a lot of ground here, so let's do a quick recap. We've looked at the options you have with traditional estate planning strategies, and we've talked about why these options just don't give you the protection you need. We've touched on the basics of the Family Wealth Trust, the foundation of our legacy wealth plan, and we've shown you some of the life-changing benefits you can get with good planning. So now let's ask the really important questions. What would your perfect plan look like? Obviously, you'd want to address all the key issues we've talked about here: protection from taxes, creditors, and lawsuits, an ability to distribute your assets the way you want without any intervention from the court, protection from probate both while you're alive and after you're gone, a way to pay for long-term care expenses without depleting your life savings, the means to pay for your funeral without your children having to worry about the cost, the ability to protect your children's inheritance from things like divorce and poor money management skills, and a way to provide for family members with special needs even after you're gone. And of course, you'd want a way to capture your legacy so that the life story you've worked so hard to create is preserved for your children, grandchildren, and future descendants. The problem is, this kind of comprehensive estate planning simply didn't exist. I'm serious, traditional estate planning just couldn't address all these issues, so we had to create a plan that could. We call it the Legacy Wealth Planning Portfolio. This single portfolio binder contains all the pieces of your legacy wealth estate plan, everything you and your family need to secure and protect your future. In the first section of the binder, we'll include complete instructions to your family on exactly what they need to do in each situation. We refer to this as the owner's manual because it's literally a step-by-step guide to your legacy wealth estate plan. And of course, if there's confusion, our office staff is just a phone call away. The next section of your legacy wealth planning portfolio has the actual documents we'll prepare for your family. The Family Wealth Trust, with the subtrust, protects against remarriage, divorce, lawsuits, and creditor claims. but it may also have incentive provisions or protection for special needs heirs. We'll also include the pour-over will, the property agreement, the durable power of attorney for property, the durable power of attorney for health care, the living will, the current HIPAA medical authorization forms, and a funeral trust ready for filing. We also give you a way to create family biographies that capture the memories of a lifetime. We explain how to distribute the family heirlooms and treasured personal items that may not have much commercial value but are important to your family. In fact, these are the things that cause kids to stop speaking with each other and generally ruin the family relationships. We show you how to designate who gets which family photos or other miscellaneous but important items. And finally, we provide a place to pass on family wisdom, stories, and folklore. It's all part of the Legacy Wealth Planning Portfolio, exclusively available from our firm. As an added benefit, we give you an electronic copy of all your document files on a flash drive, so they're accessible at any time. You'll just need to insert the flash drive into any USB port on your desktop or laptop computer. And because protection from nursing home costs requires a different planning process, we'll analyze your estate and determine what kinds of trusts are most appropriate. If we want to shield assets from being counted for purposes of Medicaid eligibility, for example, we'll need to create a special wealth preservation trust in addition to your other documents. But don't worry, we'll go over everything in our first meeting so you'll know exactly what will work best for you. Now, once you've got your family wealth trust and other documents in place, I'm sure you'll be feeling pretty good about the protection you provided for your family. But what if things change? What if a new law is passed or a new strategy evolves? Or even more important, you have life changes that need attention. Again, not to worry. We don't see estate planning as a one-time transaction. It's a continuing dance, and we'll be there for you to make sure your plan gets a regular review for potential updates. Now let's answer the question we know everyone is thinking about. How much will this cost? We know you can buy a one-size-fits-all bare bones living trust for $30 down at a stationery store. You can also spend $300 for one of those word processor documents cranked out by many attorneys. But we also know you're not going to get even a fraction of the protection you really need from those documents. And ultimately, it's not the paper you're buying here. It's the individual expertise and counsel to help you design a customized plan that meets the needs of your family. So if you're looking for a cheap, mass-produced word processor document, we're not the right law firm for you. But we also know that you work hard for your money, and the idea of the old law firm retainer setup just doesn't work. We want you to know exactly how much your planning will cost, so we charge a flat fee. And this is per family, whether you're single, married, or in a partnership. To make it easy to understand how our fees work, we've created a pyramid showing the 3 different levels of protection: silver, gold, and platinum. The silver level includes the basic family wealth trust that protects your family if you become disabled and can't manage your affairs. It completely eliminates guardianship or conservatorship court proceedings. It also contains up-to-date HIPAA forms to authorize disclosure of your medical information. It protects you from probate when you die and maximizes your protection from estate tax. The fee for this basic family wealth trust is $4,500. The second level, Gold Plan, includes additional protection. It solves the problems created by a remarriage of a spouse after the first spouse dies, and it also protects the inheritance of the children should they get divorced. If children are not financially responsible and are unable to effectively manage their inheritance, the Gold Plan protects it from their creditors. To receive this extra divorce and creditor protection, it's $4,875. Again, per family, whether you're single, married, or in a partnership. And finally, to add special extra protection from nursing home and other long-term care costs, for those of you who are particularly concerned about that, we created our Platinum Plan. This level of protection requires substantially more planning. We have to create a completely separate set of documents in addition to the Family Wealth Trust. Now, this separate Medicaid Protection Trust has very strict rules that allow you to keep assets in the family and still qualify for Medicaid. Because of this, we'll need to sit down with you and get some additional information in order to calculate the fee. But rest assured, before any work begins, you will know exactly what it will cost. And regardless of which plan you might choose, know that all of them are tailored to your needs and concerns. It's totally up to you how little or how much protection you want. Now, remember earlier we talked about the two biggest obstacles standing in the way? Well, you've definitely received all the knowledge you need today to take action. The only question now is, will you procrastinate or take the next step? And this is where that special bonus I mentioned earlier comes into play. Below this video, you'll see a Book It Now button. Just click that button and you can claim a free phone consultation with us. No obligation, no hidden charges. Just schedule your appointment and let's find out if this kind of planning is right for you at this stage in your life. If it is, we'll schedule a complete consultation to discuss your unique circumstances, and we'll go over all the options available so that you can make a truly informed decision about your family's future. And yes, if you decide to move forward, that full consultation is also free. Now, we know it's tempting to recognize that these are all great strategies and at the same time think, I'll jump on the internet and do a few Google searches and download all these forms for free. But we found nothing that resembles the resources we've shown you today. Certainly not bundled together as we've done here. And you also don't get the personal guidance and legal expertise we're offering you. And again, that's essential to creating a good plan. We're offering something you simply can't get anywhere else, and before you spend a dime, we'd like to sit down with you at our expense and find out whether this kind of planning makes sense for you and your family and whether our firm is the right fit. We want to make the next step easy for you, so we're offering a no-cost personal consultation to explain the plans more fully and determine what solution is best for you and your family. The one you pick is totally up to you. Also, our consultation is to give you a chance to get to know us and decide whether we are the law firm you wish to work with. We too get a chance to meet you and see if there is a fit. We don't work with everyone, and our meeting gives both of us an opportunity to make that decision. We believe in long-term relationships where you and your family see us as a trusted advisor who will be there when you need us long after these plans have been signed and delivered. We know you're busy, and we certainly don't want to take up your time if this isn't the right program for you. So again, this initial phone conversation is just to help you decide if you need this kind of planning at this stage in your life. So we'll just talk about your current situation and concerns. If it turns out that you're ready to take the next step, we'll give the complete consultation to you for free as well, and we'll let you choose how you want to meet. You can come into our office for a personal one-on-one, or we can simply talk in depth over the phone. It's entirely up to you. And let's include one more bonus. If you decide to take the next step, that is, if you choose to create your legacy wealth plan with us today, we'll give you an exclusive 10% discount for attending the webinar today. That's 10% off the cost of creating your plan just because you stayed with us today. But here's the catch. To get that webinar credit certificate, we ask that you agree to 3 things. First, that the appointment take place in the next 2 weeks. Next, if you're married, we ask that you bring your spouse to the meeting as well. We found that meetings are much more productive for you when both spouses are in the meeting. And the third item we ask for is a decision at the close of our consultation. Either you tell me, no, we're not ready to proceed today, or yes, let's get started. But to get that credit, you have to request your initial phone consultation. So just click that big orange button below this video to get started. Now we're just about out of time, but before we go, let me tell you a true story about a family that visited one of our colleagues at the American Academy of Estate Planning Attorneys. Several years ago, the children of a woman who had died called the law firm. The kids explained that they had been going through Mom's final papers and found a handout from an estate planning seminar the firm had presented. They also found an evaluation form that indicated she wanted an appointment with the firm to create her estate plan. They asked us whether their mother was a client and if we could please send the documents. The law firm staff searched through the database and found that yes, indeed, the mother had come to a workshop and she had made an appointment to come in, but sadly, she had canceled it a few days before the scheduled date. As it turned out, this lady had a substantial estate and had no estate planning documents at all. The firm was hired to take the assets through a very expensive probate process. Obviously, the children were not happy, and the firm sincerely wished they could have done something more to make sure she followed through with her good intentions. But alas, as with most things in life, it's entirely up to you to take action and look after things. Only you can determine what matters most to you and your family, and what plan of action you need to make it happen. Pablo Picasso, who is generally known as a genius in artistic matters, said it right when he admonished others not to procrastinate. He said, "Only put off until tomorrow what you are willing to die having left undone." Ask yourself, is this the kind of duty you'll be content to die having left undone? Do you want your children to wonder how you could have left something this important in such a mess? We hope the information we provided today was worthwhile and will motivate you to take immediate action on these important issues. Thank you for being on the webinar today, and we look forward to meeting with you.